Imagine this. A hidden pipe bursts in your condo, and suddenly your entire kitchen is ruined by contaminated water. You'd think sorting out who pays for it would be straightforward. Well, as we're about to see, this kind of battle can turn into a really complex, drawn-out fight that all comes down to the fine print.
Right off the bat, you can see this isn't just about money or damaged drywall. For the homeowner, Richard Busack, this was a truly awful situation. I mean, can you imagine your home getting torn apart and they find not just mold, but cockroaches? This one quote really tells you everything you need to know about the personal stakes here.
So this is the big question, right? Who's on the hook for the thousands of dollars in damage? Is it the guy downstairs whose kitchen is completely wrecked? Is it the upstairs owner, since it was technically their pipe? Or is it the homeowners association, the HOA, that's supposed to manage the building's common areas? The answer, you'll find, is probably not what you'd expect.
Okay, so let's dive into how this all started. It began pretty innocently. Homeowner Richard Busack gets a call from his tenant about a possible leak. But what began as a small concern, well, it very quickly spiraled into a total nightmare.
Yeah, this was not just a simple drip from a clean pipe. The source was the toilet line from the upstairs unit. That means it was what they call Category 3 water. And trust me, you don't want to know the details, but it's basically the worst, most contaminated kind. It leaked from inside the ceiling space, destroying everything, drywall, cabinets, and of course led to some serious black mold.
And you can just feel the homeowner's frustration building when you look at this timeline. The leak gets reported on June 1st. Days turn into weeks. There's some back and forth, even talk about getting new cabinets, and then suddenly the HOA just cancels the installation. By the middle of July, more than a month has gone by, and the tenant is still living with a destroyed, unusable kitchen.
So, feeling like he was being completely ignored and that this was just plain wrong, Mr. Busack decided to fight back. He took his case to an administrative hearing, arguing that the HOA was 100% responsible for all the damages.
His argument really came down to a matter of location, location, location. He said the pipe wasn't in his unit. It was in the inner walls, a space he believed was a common area that the HOA was supposed to maintain. He also pointed out that their slow response and broken promises made a bad situation catastrophic. And get this, he said their brilliant suggestion for the black mold was just to spray it with a little bleach. Yeah, that wasn't going to cut it. In this quote right here, it gets to the absolute heart of his common sense argument. He's basically saying, look, I get it. If my own sink overflows inside my condo, that's on me. I'm responsible for what's inside my four walls. But this pipe was outside of that, in a shared space. It's a distinction that honestly seems perfectly logical to most of us. Now, let's flip to the other side of the story. The HOA didn't really argue about how bad the damage was or about the timeline. Their entire defense was built on one thing and one thing only, the legal documents that govern the whole community. The HOA's position was pretty straightforward, legally speaking. They argued that the community's rulebook, the CC&Rs, is a binding contract, and that contract, they said, clearly states that individual owners are responsible for any pipes that exclusively serve their own unit. They even had an excuse for fixing the drywall, saying it was part of a bearing wall, which is a common element, but that the leaky pipe itself was a totally separate issue. So you've got two completely different ways of looking at this. One based on common sense, the other based on a contract. The entire case, the whole thing, boiled down to how you interpret a single paragraph in a dense legal document. Okay, and just so we're all on the same page here, CC&Rs are basically the rulebook for a condo complex or a planned community. When you buy a place there, you are legally agreeing to follow these rules, whether you've actually read them or not. Think of it as a contract between you and the association. And here it is, the key piece of evidence that would decide everything. Article 3, Section 3.07, titled Maintenance by Owners. The whole dispute hinged on what these exact words meant in the eyes of the law. So this text basically says that maintenance of the pipe serving a unit is up to the owner. But here's the crucial part. It says that responsibility covers the pipe from the moment it enters the unit, all the way to where it joins the main utility lines. So an owner's responsibility can actually extend outside the physical walls of their condo. And this is where the core misunderstanding happened. A simple phrase in the document said the pipe must be maintained in an open and unobstructed condition. The homeowner took this to mean physically open, that it shouldn't be hidden inside a wall. But the judge had a very different legal reading. It didn't mean the pipe had to be visible. It meant the pipe itself couldn't be clogged or blocked. A huge difference.
Okay, so with that critical contract language now clarified, the judge had everything she needed to come to a final decision.
So here's how the judge laid it all out. Step 1. The clause clearly gives responsibility to the owner. Step 2. That responsibility goes beyond the unit's walls all the way to the main line. Step 3. The leak happens somewhere along that specific section of pipe. So the logical conclusion? The HOA was not responsible. The buck stopped with the owner of the unit that the pipe served, in this case, the upstairs neighbor.
And let's not forget what was on the line, financially. Mr. Busack was asking for more than $8,500 to cover the entire restoration, the mold remediation, and the replacement of his totally ruined kitchen.
The final verdict came down to just 2 words. Based on a strict literal reading of the CC&Rs, the homeowner's petition against the HOA was denied.
The judge even made it crystal clear that her decision wasn't about sympathy or what might seem fair. Her job wasn't to decide what felt right, but to interpret the contract that the homeowners had agreed to when they bought their property. As she put it, I didn't write it, I just have to apply it.
So what can we all learn from this whole mess? Well, first, that big, boring binder of HOA documents. It's a real, legally binding contract. Second, what feels like simple common sense to you and me might not be how the law sees it. And third, your responsibility as a homeowner can, and often does, creep into those hidden inner walls. But the biggest lesson of all, read and try to understand these documents before a disaster ever strikes.
And that really leaves us all with one final question to think about. If you live in a condo or a community with an HOA, you've probably read your lease or your mortgage papers, but have you ever actually sat down and read the CC&Rs? As this case shows us, the words hidden in that document could one day be worth thousands and thousands of dollars.